Good morning, Your Honor, and may it please the court. My name is Chris Michel, and I represent the appellant. I'll aim to reserve 3 minutes for rebuttal this morning. At its core, the Dormant Commerce Clause prohibits state and local governments from discriminating against out-of-state economic interests. Hood River's short-term rental ordinances do just that in stark terms. A Hood River resident can rent a home to short-term guests simply by submitting ministerial paperwork. But the out-of-state owner of a materially identical Hood River property cannot do the same. Out-of-state owners, like my clients, can rent to short-term guests only by proceeding through a facially different and far more burdensome process of engaging a Hood River resident who is willing to both act as a long-term tenant and the de facto operator of the short-term rental. That separate and unequal system is paradigmatic discrimination.
Counsel, how is your case different than Rosenblatt in a way that matters?
So, Your Honor, Rosenblatt resolved a materially different claim by a materially different plaintiff to a materially different law.
What was different about the ordinance that is material to the analysis?
So I'm happy to address the ordinance. I do think the nature of the claim and the plaintiff are critically different as well. The ordinance was different because what was challenged there was a residency requirement that was defined in terms of physical residency, not in terms of geographic residency. And as importantly, it was challenged by an in-state resident. The second paragraph of the opinion begins by describing the plaintiff as a Santa Monica resident on the grounds that it discriminated against out-of-state visitors. So here we have a much different claim in which the ordinance, which is defined in geographic terms, precisely what the Dormant Commerce Clause speaks to, and it's challenged by out-of-state owners as discriminating against them. In fact, Rosenblatt announced the correct legal principle and applied here. It supports reversal.
Let me ask a follow-up question to that. A Hood River resident with a second home is in the same position as your clients who live elsewhere and have a second home. Why isn't that the appropriate comparison? Because those two groups are treated the same. A Hood River resident with a second home cannot rent out on a short-term basis without finding a long-term tenant or spending or changing which house is their primary residence.
Right. I think the short answer, Judge Graber, is that a Hood River resident with a first home is still treated preferentially as compared to out-of-state residents.
But why is that a relevant comparison? Because by definition, your clients don't have a primary residence in Hood River. They have a primary residence somewhere else. So they are dealing with a second home just as a Hood River resident with a second home is dealt with, and those two groups are treated the same. Why isn't that the proper comparison?
Right, for several reasons. As this court explained in the Rocky Mountain Farmers case, the way to determine whether entities are similarly situated for Dormant Commerce Clause purposes is to ask whether they compete in the same market, provide the same product in the same market. And here, there's no dispute.
A second home is the market. What do you do with your second home?
Well, the market is short-term rentals. That's what we're talking here about the Dormant Commerce Clause. The economic activity in question is renting a home.
Renting out your second home.
Well, with respect, Judge Graber, I don't think anyone who is renting the home, the customer, is concerned with or likely even knows whether they're renting a second home or the first home of the owner of the home.
But when we're dealing with the effect on your clients, we have to be thinking about who are they compared to.
Right. So the proper comparison is between the competitors in the market. And here the competitors in the market are all of the Hood River owners who are renting their homes. Now, I take your point that some Hood River owners, namely those of second homes, are not discriminated against. But the Supreme Court has been perfectly clear. I think the C&A Carbone case at page 391 is particularly clear on this point, that discrimination in favor of some in-state residents and against all out-of-state residents is still discrimination for the Dormant Commerce Clause purposes, even if some in-state residents are also subject to the discrimination.
Here we got the same town. It's granted, you could have an argument, and that seems to speak to somebody who lives in Eugene and has a second home in Hood River. But here, I'm not sure that I understand exactly what the discrimination is. It may be true that somebody who has two homes in Hood River can play some games with regard to which is the primary residence. It may be that they have places they go back and forth to, but in terms of the discrimination, they get treated the same way as someone who lives across the river and happens to have a second home in Hood River.
So a couple of responses, Judge Clifton. First, the CNA Carbone case, I do think is squarely on point. In that case, the favoritism was of a single waste facility in Clarkstown, New York. And some of the complainants in that case raised, the defendant in that case raised the point that there was discrimination against in-city residents. And the Supreme Court said it doesn't matter as long as there's discrimination in favor of in-city residents and against out-of-state residents. It doesn't matter that there's also discrimination against other in-city residents. I think that legal point is well established in Supreme Court case law. Now, as to your question about what's the discrimination here is stark. If you're a primary resident of Hood River, you can short-term rent your property simply by presenting evidence of your residency. If you are not, if you're an out-of-state owner, true, also if you're from somewhere else in Oregon, but what matters for the Dormant Commerce Clause is if you're an out-of-state owner, the only way to do that, to short-term rent your property, is to partner with a Hood River local tenant who is willing to do the following: qualify as a tenant through their 3 separate means of identification, live in the property for more than a year, vacate the property for a series of short-term renters, and vacate the property when the owners want to use it. So just on its face, that is dramatically different, starkly different treatment, which falls squarely within what the Dormant Commerce Clause protects against. I also want to address Judge Graber's question, and your question as well, Judge Clifton. If these were really differently situated properties, in other words, if second homes and primary residence were different categories for Dormant Commerce Clause purposes, nothing would stop Hood River from banning out-of-state owners from renting at all. And in fact, that's what the earlier version of the ordinances did.
But we're not dealing with the earlier version. We're dealing with a version that allows everyone to participate in the short-term rental market by finding a willing tenant at a minimum.
Well, I think with respect, Judge Graber, the reasoning that was underlying the question and that my friend to some extent invokes is that these two entities are differently situated. And if the court were to adopt that reasoning, I do think it would support an outright ban.
Well, I guess it's not really a question, it's more of an observation that we're dealing with the current ordinance, not the past ordinance, correct?
No doubt about that.
Okay.
But as I was saying to Judge Clifton, the current ordinance is still dramatically discriminatory in that primary residents can short-term rent with no further steps other than demonstrating residency, and out-of-state residents can do so only through the far more burdensome mechanism of engaging a local tenant. That's actually discrimination twice over. First, by creating this preferred mechanism for the local residents, and then by having the second-rate measure for out-of-state residents depend on engaging the local tenant. So what Hood River is trying to do is effectively reserve the local market for its local residents. And that is what a long series of Supreme Court cases, including all of the waste treatment cases like Granholm, about wineries, have said is impermissible discrimination under the Dormant Commerce Clause. It's effectively a local business partner requirement that's not different from what the Supreme Court rejected in Granholm. And yes, to one of Judge Clifton's questions, the Dormant Commerce Clause deals with substance and not labels. Granholm would not have come out differently if those had been described as primary resident wineries as opposed to in-state wineries. CNA Carbone would not have come out differently if Clarkstown, New York had described the waste treatment facility that it was preferring as a primary resident waste treatment facility. What matters is the economic substance. And here there's an economic option available to local residents on starkly different and more favorable terms than are available to out-of-state residents. And that is in the heartland of what the Dormant Commerce Clause prohibits. Now, that's not to say that the city doesn't have regulatory tools at its disposal. The city can regulate in all manner of ways to deal with its concerns about land use, as long as it doesn't discriminate on the basis of residency, which is what the Dormant Commerce Clause protects. And in fact, in the record is a study in which the city came up with 17 different ways in which it could address its concerns about affordable housing, tellingly none of which were discriminating against out-of-state residents. Instead, the city did what cities sometimes do. They preferred their local residents over the unrepresented and unpopular out-of-state tenants or out-of-state residents. But that's exactly what the constitutional provision at issue here, the Dormant Commerce Clause, is around to protect. And if the city does regulate in an even-handed way, all we ask is that it live by the same rules for its own residents that it subjects or imposes on out-of-state residents. I do think that's the most straightforward way to decide this case, facial discrimination. The rule is clear that if the law facially discriminates, strict scrutiny applies. The city is not defending the law on the basis of strict scrutiny. I think that's pretty clear why, given that it had 17 other options by its own account, and it chose the one that is discriminatory. But that's not the only way to decide the case. We do also have an argument under Pike balancing. If the court were to decide that the law is not facially discriminatory, or perhaps if the court decided not to decide that issue, reversal would still be warranted under Pike.
What's the interstate commerce that's substantially affected?
Here, it's out-of-state owners renting their in-state property. That's undisputedly, I think, interstate commerce.
But that's the business of Hood River. I mean, basically, it's one of the things that seems odd to me about this case is that Hood River has made it harder to attract visitors that don't want to stay in a hotel. They want to stay in some Airbnb or equivalent VRBO. How is there a substantial impact on that by the fairly limited number? I mean, we're not talking about a huge community here, the fairly limited number of properties affected.
Well, Judge Clifton, it's a substantial burden in that market. I don't think the court has said, you have to look at the total economy, as a whole. And in fact, it burdens the entire market. The classic example is the Pike case itself. That was about cantaloupe packing in Arizona. I don't think, with all due respect, cantaloupe packing in Arizona is a major component of the national economy, but the Supreme Court nevertheless said that the substantial burden on that market counted under Pike purposes because, as here, it effectively forecloses out-of-state owners from this commercial activity. In fact, and I don't think there's a dispute with my friend on this either, nobody has actually run this procedural gauntlet and used the long-term tenant option to successfully rent. That's why the district court invented a hypothetical tenant, in the opinion, to say that that alternative actually provided an accommodation. But in the real world, no one has done that, and that is a substantial burden. If there's no further questions, I'd like to reserve the balance for rebuttal. Thank you, Your Honor.
Good morning. Thank you. May it please the court, counsel. As this court previously stated in Rosenblatt, and this case is indistinguishable on principles, the sort of arrangement that the city of Hood River has enacted is simply not discriminatory. It treats Hood River residents who have a second home the same as Portland residents that have a second home, the same as out-of-state residents that have a second home.
Well, in practical terms, I'm not sure that's true. I mean, if you have a first home in Hood River, it's easy to pass yourself off as a resident of Hood River, and you can decide which address you want to claim for voting or whatever. I don't know enough about the geography of Hood River or how the residential area is zoned separately, but it does seem that the paperwork burden, at least, would be substantially greater. In fact, it's more than just paperwork. If you have that short-term tenant alternative, which Rosenblatt seems to put forward, has anybody actually accomplished that?
Your Honor, I can't speak to whether or not anybody has actually accomplished that in Hood River, but I can personally speak to how it's been accomplished in Santa Monica. And in Santa Monica, I've stayed in Airbnbs where the garage was turned into a ADU. The person who's there serving as the host lives in the ADU. We rented the main house and we never saw that person. The difference is a resident of Hood River could rent their primary residence.
Well, but the problem is that to establish that long-term tenancy, they're required to show up with, for one thing, they got to kind of be there for a year because they got to come up with a tax return with that address, and it's going to have to be last year's tax return. So you're required to find a tenant who will be there, and you've got to wait a year before that person can qualify in order to satisfy the ordinance.
Yes, sir.
That seems like a pretty substantial difference in the requirement imposed upon somebody who's from Hood River.
Not if they're renting the second home, Your Honor, because anybody who's from Hood River who's renting their second home would have to do the exact same thing. And that's the important qualification. It is not just whether you're acting in the same economic market. It's not just whether you're to be similarly situated. You also have to look beyond that at what is the service or product that you're providing. Here, those homes that are second homes sit vacant in Hood River for the vast majority of the year. A residence, by definition, has somebody in it. The purpose of this ordinance was to encourage long-term rentals, opportunities for people who otherwise wouldn't have an opportunity to rent in the city of Hood River. It's not that big a stretch to turn a long-term rental, turn your garage into an ADU, into a profit-bearing short-term rental that you can rent through Airbnb. That's the exchange that the city of Hood River has asked plaintiffs to make, which is, okay, you don't live here, so you're not really residential. You want to use our residential properties in order to profit, and okay, the exchange is make it something that works for our town that has a very serious problem given the nature of the quick growth that's happened over the past 10 years, the boundaries of the Gorge Scenic Area, and other limitations on their ability to produce
Well,
housing.
why couldn't the city simply ban vacation rentals?
They could, no problem.
That would
Wouldn't
have
even be an issue.
that would seem to become a lot closer to the goal trying to be achieved, which is to eliminate the vacant places and have more places for people that actually live there.
I don't agree with you there, Your Honor, and here's why. Simply banning that would mean that there's no short-term rental. There'd be vacation homes that remain vacant. There'd be no incentive for the people who own those vacation homes to rent them to long-term tenants. The important thing is, it's not just market actors. You've got to look at the purpose of the regulation in order to determine whether it's discriminatory, whether this is a focus on location, geography, or whether this is a focus on the purpose of the statute. And I'm glad that council mentioned Rocky Mountain Farmers Union, because in Rocky Mountain Farmers Union, we're talking about ethanol, completely ubiquitous and fungible substance that gets mixed up, comes from all over different areas of the world. But what they said was, if we ignore the real differences between ethanol pathways, we cannot understand whether the challenged regulation responds to genuine threats of harm or to the mere out-of-state status of an ethanol pathway. All factors that affect carbon intensity are critical to determining whether the fuel standard gives equal treatment to similarly situated fuels. Under the Dormant Commerce Clause, distinctions that benefit in-state producers cannot be based on state boundaries alone. But a regulation that is not facially discriminatory simply because it affects in-state and out-of-state interests unequally, it is not facially discriminatory. If California is to assign different carbon intensities to ethanol from different regions, there must be some reason apart from their origin to treat them differently. The only reason that we're treating anybody differently is because of the status of their home. Is that a residence, or is that something that you're looking to make money off of? Is it a home or is it a business? That's a fundamental distinction that this court in Rosenblatt recognized means you're not similarly situated. I'd like to turn to the Pike argument, and that is plaintiffs haven't come up with any evidence of an impact on interstate commerce. They've got 6 declarations from the previous version of the statute, not the amended one, how it was the previous one was impacting them. That's not interfering with interstate commerce. That interferes with a few market actors, but interstate commerce is far vaster than that. And frankly, you don't just look at the market within Hood River, you've got to look at commerce throughout the states. This court has found that even market actors that are impacted in millions and billions of dollars don't impact interstate commerce. So they didn't even meet the threshold to get to Pike. And then if they had somehow, if this court were to believe that they had somehow met that threshold, end of the day, the city of Hood River had a very legitimate reason to enacting the statute that it did. It had the housing needs analysis in front of it. It had the housing strategy in front of it. This is not the only tool that they've used. They've also made efforts to develop housing. They've made it easier for local people to find housing. They've aided as much as they can with other policy tools. This is one tool in the tool basket. It shouldn't be thrown away because a few market actors don't want to invest a little money in their business. It's all it takes. It really isn't that difficult. You don't have to go out and find somebody who's willing to come up with a,
Well, what do you
Of
mean,
some sort.
invest a little money? What,
just finish your basement. You get a
Well,
finish, that's the same unit.
you
Somebody
can
lives
finish it, but you
downstairs.
still have to get that long-term tenant who's lived there for a year in order to have a tax return at that address. And you can't tell us that anybody has actually checked off those boxes, so why shouldn't we understand that to be a burden?
Well,
A
Your
burden
Honor,
that doesn't have to be faced necessarily by somebody who has a local address they can play with.
I would say this, Your Honor. I understand the concern. This motion was early in the process. The complaint was filed.
Well, and you're not defending the previous iteration of the ordinance. I mean, that is somewhat telling as well. I mean, because Rosenblatt comes out or somebody hits upon it,
Mhm.
let's amend this, and there's no effort being made to defend the ordinances that were in place when the litigation commenced.
I agree with you there, Your Honor, and the reason for the amendment was the guidance from this court in Rosenblatt. We specifically tailored the ordinance to enable the city of Hood River to advance the policy interest that it needed to and comply with its obligations under the Dormant Commerce Clause, as this court stated in Rosenblatt. I, I, I don't know in the face of that what this city should have done, short of simply banning short-term rentals entirely, which I think, as I've mentioned, would have hampered their ability to provide an incentive for people whose houses otherwise would remain vacant to use those to house people who need it in the city of Hood River.
Your colleague has offered reasons that he thinks that distinguish Rosenblatt from this case. What do you have to say to those?
The different position of the parties and plaintiff, entirely beside the point. The fact that their statute, their ordinance was a little bit different, again, entirely beside the point. The issue was, does this impact similarly situated players in the same way? And it does. Owners of second homes who are residents of Hood River, who are residents of Portland, who are residents of Minneapolis, Minnesota, are all treated exactly the same. The incidental burdens shared by equally. There's no discrimination.
Somebody who has a primary residence in Hood River, is there any limitation on their ability to rent that out during times they plan not to be there themselves?
The limit is on the number of days. They couldn't rent it in excess of 90 days.
Well,
90 days is the
that's-
cap.
I mean, I once dated a woman who was from whatever the town and across the state line in South Carolina is from Augusta, Georgia. And it's famous across the country now. People devoted to the masters will pay enormous amounts of money to rent a house for a couple of weeks. And people who live there and aren't planning to stick around make enormous amounts of money by leaving for a couple of weeks. I don't know, the Hood River has that singular attraction, but that gives somebody who actually lives there an opportunity to say, okay, I'm going to rent this out when I'm going to be away anyway, because most people are away for some period of time.
Of course.
Should that be taken into account somehow? They can do things that somebody who doesn't have a primary residence in Hood River can't do?
I don't agree with you that they couldn't do that. I would say that as a second home, any of these plaintiffs, if there were a singular attraction that attracted that much attention and that much interest, could rent their home during that time, provided they had also shown that that property was available and being used as a long-term.
But you'd have to have a tenant who's, I mean, you could try to schedule, I'll rent this out when the tenant's going to be gone. That's something a little harder to control when it's your own planning that you're talking about, when I'm going to be gone.
Fair, Your Honor. I wouldn't say that it's easy. I would say this. The Dormant Commerce Clause does not say that market players get to use the most convenient method, their preferred method, the method that they choose. What it asks is that what burdens are shared in similarly situated market players are shared across the board. And that's exactly what happens in Hood River.
Well, the requirements for that tenant to establish residency there do strike me to be unusually burdensome, particularly the tax return, because that's what requires someone to have lived there last year to file a tax return there last year before they can check off that box.
I understand what you're saying, Your Honor. I don't agree that it is a burden constitutionally, but if this court were to decide that those provisions were a burden constitutionally in some way, there is a severability provision in the ordinance that those particular terms, if they're unconstitutional,
Except that burden is the same for a second home owned by someone who lives in Hood River,
I agree,
correct?
Your Honor.
Okay,
Absolutely.
so presumably, we don't know, but presumably the plaintiffs who live wherever they live can rent out their primary residence as they wish.
Absolutely.
And so just as a Hood River resident could rent their home for the 90 days. But it does seem like a big burden, but the burden of getting the long-term tenant, is there any difference in the ordinance as to the requirements for showing the long-term tenancy as between the plaintiffs and a Hood River resident with a second home?
There is not, Your Honor. No. And I was not saying that those terms violated the Constitution, just saying that severance is available if that was necessary. If there are no more questions, I'll close. Thank you.
Thank you, Your Honor, and may it please the court. Just a few brief points in rebuttal. I think the easiest way to resolve this case is to imagine two houses right next to each other on the same street in Hood River. They have the same number of bedrooms, the same number of bathrooms, the same amenities, and the same rental price. If you're a customer renting one of those houses, they are exactly the same to you. My friend mentioned that he rented an Airbnb in Santa Monica. I noticed he didn't talk about who owned that Airbnb. That's probably because he didn't know and a normal customer would not know. When you're looking at dormant commerce, you look at what the market, what the product that is presented to the market is. And here those two products are identical. Now, the next step. If one house is owned by a primary resident of Hood River, defined in terms of geography, residency in the state, that person can rent out the property with no further steps. If the next door neighboring home is owned by one of my clients, an out-of-state resident, the only way they can do it is through a burdensome tenant requirement that my friend concedes has never existed.
Your entire argument is premised on rejecting the idea that being a second home matters. But isn't that what Rosenblatt says is okay?
With respect, no, Judge Graber, because there was no out-of-state owner in Rosenblatt to make that argument. The second, the
The
tenant...
case holds what it holds about what is comparable to what, though, does it not?
But I think it's critical. What the case held was that the Dormant Commerce Clause claim raised there, that there was discrimination against out-of-state visitors, was impermissible. It's true that there's language about out-of-state owners, but there was no out-of-state owner making that claim. And Rosenblatt then says clearly in footnote 5, it reiterates Granholm, and it reiterates the principle that if an out-of-state owner had to become a resident in order to compete on equal terms, that would violate the Dormant Commerce Clause. Under a
Your
long line of
clients
cases
do
like-
not have to become residents. They have to find a tenant
in order to compete on equal terms.
with, on
Right.
equal terms with Hood River residents who have a second home that they want to rent out.
I understand that position, Judge Graber, but with respect, I think that's misdescribing the comparison, because as I began with, a customer who is looking at the market is not going to draw any distinction between the owner of a first home and the owner of a second home in Hood River. Those are the same product. And critically, as I said earlier, and I don't think my friend had a response to that, that rationale that those entities are differently situated would support a ban on all renting by out-of-state owners with no tenant option. That's a position that the Fifth Circuit has squarely rejected, the California Court of Appeals has squarely rejected, and would be deeply inconsistent with Supreme Court precedent. So I'd urge
Okay,
the court-
counsel, thank you.
Thank you, Your Honor.
Okay, that matter is submitted. Next, we have Ford versus St. Charles Health System.